a federal judge issued a temporary restraining order preventing anyone from auditing the Treasury Department, including the Treasury Secretary himself. We're all too familiar with the progressive left making political use of friendly federal judges to hand out nationwide injunctions when they lack the legislative power to assert their political will. It seems there's always a helpful Hawaiian judge when the progressive left needs one. The question is, what to do about these unelected judges with supposedly lifetime appointments who seem determined to act as though they possess greater executive branch authority than does the elected president. Impeachment is always an option, but it's a heavy burden, requiring a full 2/3 of the Senate. That supermajority is a stretch, except under the most egregious of circumstances and highly unlikely today. There is, however, an easier way to remove an overreaching judge from the bench. Let's talk about it. I am, of course, attorney Andrew Branca for the Law of Self-Defense. Hey folks, I want to take just a moment to invite you all to our upcoming live and 100% free Law of Self-Defense Hard to Convict webinar. This free webinar teaches you how to be hard to convict if you're ever compelled to use force in defense of yourself, your family, or your property. The webinar is live streamed by me personally, and there's plenty of opportunity for Q&A. Best of all, it's 100% free, but we do limit seats to allow for adequate Q&A. So I urge you to grab your seat right now by signing up at lawofselfdefense.com/hard-to-convict. So I don't intend to read through Judge Engelmeyer's TRO with all of you in detail. Plenty of other lawyers on the internet have been doing that. And in any case, it expires at the end of the week and maybe much sooner. I will, of course, include in the description a link to the TRO for those who are interested in reading it. I will say that the TRO strikes me as shady as F on many levels. The timing of the TRO alone must surely raise eyebrows. It was entered around 1 a.m. this past Saturday, when Judge Engelmeyer was serving his turn as an emergency judge, a role that would have been known to the plaintiffs and which therefore suggests judge shopping. By the way, you know who else received an unpleasant court order issued in the middle of the night besides Trump? The practicing Christians will know. It was Jesus, when the court that would send him to his ultimate crucifixion handed down their conviction in the middle of the night. The irony. In addition, the TRO here was granted ex parte, meaning nobody from the Trump administration was present to have an opportunity to argue against it. And of course, Judge Engelmeyer is an Obama appointee and has known Democrat political inclinations. All of this is enough to create a stench of this being a politically motivated ambush by Judge Engelmeyer at the behest of the anti-Trump officials of the 19 plaintiff states who asked for this TRO. The scope of the TRO is also bizarre, given that it applies to all political appointees, which necessarily includes even President Trump's appointee, Treasury Secretary Bessent, the most senior executive branch officer at the Treasury Department. Even he is prohibited from accessing Treasury Department payment systems. The order also raises constitution-level separation of powers questions. The federal government has, of course, per the Constitution, 3 major branches of government: the legislative branch under Article 1, the executive branch under Article 2, and the judicial branch under Article 3. These are often described as co-equal branches of power, but that phrase can be a little misleading. They are equal only in the sense of each having plenary or ultimate power within their respective realms, unless otherwise constrained by the Constitution. Generally speaking, this means that the legislative branch has the sole power to create law, the executive has the sole power to administer law, and the judicial branch has the sole power to settle disputes. It also means that each branch is to be largely independent of the other branches within its plenary domain. For example, the judicial branch is not to have the authority to mandate how the executive branch administers the law, which would seem to be precisely what Judge Engelmeyer is doing when he prohibits even the Treasury Secretary from accessing Treasury Department payment systems. Even federal judges have only limited legal authority. Otherwise, the nearly 1,000 federal judges would each be their own unelected black-robed dictators. Certainly, a court order issued by a judge ought to be obeyed, but only if it is a lawful order. For example, if Judge Engelmeyer had ordered Treasury Secretary Bessent to vote for Kalama Harris, no one would reasonably argue that this was a valid order that Bessent was legally obliged to obey. An unlawful order is without legal authority or effect and is properly ignored. So it's a real question whether Judge Engelmeyer, obviously a member of the judicial branch, even has the legal authority to issue an order restraining the Treasury Secretary from accessing Treasury Department records, given that accessing these records is a core executive branch privilege and necessary to the executive function. This is, in fact, the very argument that the Trump administration made the moment courts opened on Monday morning following Judge Engelmeyer's 1 a.m. Saturday night TRO, when the Trump administration submitted an emergency motion, a request to the court to dissolve, clarify, or modify Engelmeyer's ex parte TRO. As the Trump motion to dissolve the TRO notes, Judge Engelmeyer's order is, quote, a remarkable intrusion on the executive branch that is in direct conflict with Article 2 of the Constitution. Basic democratic accountability requires that every executive agency's work be supervised by politically accountable leadership who ultimately answer to the president. A federal court consistent with the separation of powers cannot insulate any portion of that work from the specter of political accountability. No court can issue an injunction that directly severs the clear line of supervision Article 2 requires. Because the order on its face draws an impermissible and anti-constitutional distinction, it should be dissolved immediately. End quote. Yes, exactly correct. And it's not only the Trump administration that's alarmed at Judge Engelmeyer's dark 30 overreach of his judicial authority. Engelmeyer, remember, only issued this TRO because he was taking his turn as the district court's emergency judge on duty Saturday night. The TRO was therefore only to last for 1 week, when the entire matter would be turned over to a non-emergency judge. In this case, that's federal judge Jeanette Vargas, who would take over the case at that time. But Judge Vargas is not waiting until the end of the week to get her hands on this matter. On Monday morning, she immediately issued her own order requiring a meeting of the plaintiffs and the Trump administration that day to attempt to resolve the issues covered in Engelmeyer's TRO. If no agreement is reached, Judge Vargas then orders the plaintiffs, the 19 states that sought the TRO, to respond to Trump's just filed objection no later than 5 p.m. on Monday, the same day, and for Trump's lawyers to respond to that no later than 11 p.m. on Monday. If that seems all a bit quick for a typical court, that's because it is. Judge Vargas seems keenly aware that Judge Engelmeyer's TRO has created an immediate constitutional crisis hot potato that Engelmeyer then tossed directly into her lap. And she wants this hot potato resolved right now. So that's where things stand with respect to Engelmeyer's TRO as I record this show. My focus here is not really on the TRO per se, however, but on what can be done to remove overreaching judges, arguably like Judge Engelmeyer, from the bench. Were we to decide that doing so is a good idea? Obviously, whether it's a good idea is an entirely separate question. I'll circle back to that later. And I'm not the only person wondering about removing Judge Engelmeyer. None other than Elon Musk, leading the DOGE audit initiative for President Trump, and whose people the TRO seems largely aimed at, has posted on X calling for the impeachment of Judge Engelmeyer. That post was made on Monday morning, shortly before I recorded this show, and already has over 15 million views and over 100,000 likes. Now, impeachment has been used a number of times to remove federal judges from the bench, and the power of impeachment as a power of Congress is defined in Article 1 of the Constitution. Importantly, what we commonly refer to as impeachment to remove a government official is really a two-step process. Impeachment is merely the first step. We also need a subsequent conviction in order to remove the official. You can think of that initial impeachment as being a kind of an indictment. And that falls squarely within the authority of the House of Representatives under Article 2, Section 2 of the Constitution. Impeachment requires the votes of a mere majority of the House. The actual conviction, if it happens, is decided by the Senate under Article 2, Section 3 of the Constitution. Conviction requires a supermajority, 2/3 of the Senate, or 67 votes in our current Senate of 100 members. Interestingly, Article 2 of the Constitution defines the powers of the executive branch and the president and sets out the conditions for impeachment. That Article 2, conditions for impeachment, found in Section 4, reads, quote, "The president, vice president, and all civil officers of the United States shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors." Close quote. However, although the powers of the judicial branch are defined in Article 3 of the Constitution, Article 3 provides no directions for the impeachment of a judge. We strangely have to look at Article 2, defining the executive branch, to look for conditions of impeachment for an Article 3 judge. And that's exactly what we've done historically. Some 15 federal judges have been impeached by the House, and 8 of these have been convicted by the Senate, applying the conditions of impeachment found in Article 2. So that's certainly been our legal practice, and I'm not aware of any real objections to it. Even here, we don't find the word judge, but as a matter of practice, we've been treating federal judges as if they were civil officers and therefore subject to the impeachment process. Again, however, the impeachment process requires a majority of the House and 2/3 of the Senate, a high hurdle, and it requires that the judge be deemed guilty of treason, bribery, or other high crimes and misdemeanors. The phrase high crimes and misdemeanors has been defined to not require an actual criminal law violation. Donald Trump's second impeachment, of course without conviction, cited no criminal statute having been violated, but still was permitted to proceed. But clearly, high crimes and misdemeanors suggest some rather reprehensible, intentionally malicious, shameful conduct. Mere incompetence, for example, would be hard to classify as even a misdemeanor. But what if you have a federal judge whose conduct doesn't rise to the level of a high crime or misdemeanor? Or you don't believe you can secure 67 votes in the Senate? Is there no way to remove the judge from the bench? In fact, there is, because impeachment is not the only way to remove a judge. A judge can also be removed for failing to comply with his constitutionally mandated conditions of employment. These are found in Article 3, Section 1, which reads, quote, "The judges, both of the Supreme and inferior courts, shall hold their offices during good behavior." Note that phrase, shall hold their offices during good behavior. The only reasonable reading of this is that a judge can be removed from the bench for failing to hold their officers during good behavior, and instead by having engaged in some official capacity of bad behavior. The first thing I note here is that bad behavior need not be behavior that rises to the level of high crimes and misdemeanors, and indeed should not be read as meaning the same thing. The founders clearly knew how to write the words high crimes and misdemeanors, and if that's the standard they wanted applied in Article 3, Section 1, they simply would have written that instead of writing bad behavior. So there's no need to prove that the judge engaged in some rather reprehensible, intentionally malicious, or shameful conduct necessary to meet the burden of high crimes and misdemeanor. Some lesser degree of misconduct would presumably be sufficient for removal for the failure to be on the bench under good behavior. Now, what might bad behavior look like? Well, judges are required to meet certain expectations in the performance of their duties. Indeed, these expectations are set out by the judiciary itself and can be found in the Code of Conduct for United States judges. I'll put a link to the Code of Conduct in the description, but the headings you can see here are pretty much tell the story. A judge should uphold the integrity and independence of the judiciary. A judge should avoid impropriety and the appearance of impropriety. A judge should perform the duties of the office fairly, impartially, and diligently. By these standards, a judge who, for example, simply stopped showing up to work would be failing to hold their offices during good behavior and could be removed on that basis, which only seems fair enough. So let's say we have a judge who is engaged in bad behavior, but not conduct sufficient for an impeachment. What should be the procedure for removing that judge? Well, impeachment requires proof of high crimes and misdemeanors, That requires a vote of half the House and 2/3 of the Senate. But bad behavior is misconduct of a much lesser degree. To be found liable for bad behavior is much less shaming than to be found guilty of a high crime or misdemeanor. And just as we require a lesser legal threshold for liability on a speeding ticket than we do for guilt on a felony charge, we should require a lesser legal threshold for liability for bad behavior than we do for high crimes and misdemeanors. I propose that a reasonable threshold for bad behavior removal would be a simple majority vote in both the House and the Senate. That means no supermajority vote of 67 would be required in the Senate to remove a judge from the bench for bad behavior, as would be required for impeachment. Get half the House and a mere 51 in the Senate, or just 50 and the tie-breaking vice president vote, and the judge would be removed for bad behavior. Is it possible that the Republicans could successfully remove Judge Engelmayer from the bench in this way for some bad behavior? Perhaps failing to uphold the integrity and independence of the judiciary by acting as a political activist of the progressive left? By engaging in the production of a TRO that fails to avoid impropriety, or at least the appearance of impropriety? By failing to perform his duties fairly, impartially, and diligently? I mean, why didn't the judge even try to contact the Trump administration lawyer for their input in opposition to this TRO, and instead move forward on an ex parte basis, hearing only one side of the argument in the middle of the night? It's not like a Trump administration lawyer would have been difficult to get a hold of. The Republicans do have a majority of the House and also of the Senate. So it certainly would be possible for them to remove Judge Engelmayer on the basis of bad behavior, applying the process I just described. But there are two wrinkles to consider. First, although the Article 3 employment conditions on federal judges said they hold their offices during good behavior, and that text has been in the Constitution since its ratification, this language has never, not once, been actually applied to remove a judge. The judges that have been removed were removed by impeachment. The process I described for its application of removal for bad behavior would certainly be a reasonable one, but it's never actually been done before. So one would expect the opposition to throw up all kinds of procedural roadblocks, if nothing else. Second, we have to keep in mind those who live by removal for bad behavior also die by removal for bad behavior. And someday, the Democrats may again have their own bare majority in the House and the Senate. One of the favorite pastimes of the progressive left these days is to hurl accusations of alleged misconduct at the purportedly conservative members of the Supreme Court. Justice Clarence Thomas is a particularly favorite target, but Gorsuch, Alito, Kavanaugh, and Barrett all get their share of red-faced screaming allegations as well. Does anyone doubt that if the kraken of removal for bad behavior were unleashed on Judge Paul Engelmayer, that it wouldn't in turn be unleashed on Thomas, Gorsuch, Alito, Kavanaugh, and Barrett, and any other federal judges who didn't rule in the progressive way when the progressives were, again, transiently in the majority in Congress? And if it were applied in that way, would the conservatives have much basis to object after having done just that to Engelmayer? Something to think about, I think. Perhaps removal for bad behavior should not be our first choice, when really what's at stake here is just a temporary restraining order that expires at the end of the week, and maybe, if Judge Vargas has her way, well before then. And that's about all I have to say about that. I'll close up by reminding all of you that if you carry a gun so you're hard to kill, that's why I carry a gun so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to know the law so you're hard to convict as well. Until next time, I remain Attorney Andrew Branca at lawofselfdefense.com. Stay safe.